Good morning, everybody. All my co-panelists and all the dignitaries and invitees. The subject today, state welcome subject today is the access to justice is theme and the role of the tribunals and importance of tribunals. They say that the quantitative, since with my experience as the DJM of Karnataka Appellate Tribunal, not only quantitative but qualitative work is also done. How I will tell you. My first opinion is the tribunals are not just alternative, but they are the best alternative for the common man to get easy justice, speedy justice, and little the procedural hurdles. So when I took up this membership as a tribunal member in July 2009, I did little know that it was the very good institution where I joined. After 2 months, when I started disposal of the matters, particularly Karnataka Appellate Tribunal, I was given the tax bench. Friends, the tax bench for the district judges is a challenge because we never studied CA. I am not a BCom graduate, but I am very happy to tell you that for 2.5 years, the chairman did not change me from that bench. Because with the cooperation of the department member, I was able to do the best, and my department members were telling me that, no sir, we have to learn a lot. So after 2 rounds of the department litigation, the tax benches, that means one assessing officer, another is first appellate authority. The appellate tribunal, though it is second appellate authority, but it's not second appellate authority, it is first appellate authority. The 2 rounds of government litigation, department litigations, I considered it as one. How the quality work was done, I want to quote from my experience. It was the tax matter relating to IBM that I have written that judgment. Whether ERP service, Entrepreneurial Resource Planning Service, involves any transfer of goods or not. That was the issue. See, my department members were telling me that, no sir, we are interested in revenue. First I told them, here you are not the department member. You are the presiding officer of the tribunal. You must see that whether the recovery is according to law or not. You are not sitting here to protect the revenue or damage the revenue. Then with their help, I said, no, you give me the facts. I will put it in the frame of law. Because the matter, it goes to the High Court. The High Court will definitely look into the aspect of the district judge, what he has done in the first appellate authority. Therefore, with their cooperation, what happened in that case, every time they were writing the judgment in favor of the revenue. Then I told that even if I remand it to the first appellate authority, again back the same will come. Then I wanted to put an end to this. How? As a first appellate authority, we had the provision for taking evidence on this point. The lower courts have not taken any evidence on this point. And I told them, requested both sides, please provide evidence because this is a technical aspect. Enterprise resource planning is technical. So please provide evidence on this. We will take evidence in the tribunal and we will decide it. See, after taking evidence, both agreed, and after taking evidence from both sides, I wrote the judgment and held that in ERP service, no transfer of goods takes place, but there may be service tax component. And that judgment was upheld by our Honorable High Court in Sasken's case. And recently, where I was practicing Dharwad bench of Karnataka, some tax lawyers met me and told me that this judgment is also upheld by the Honorable Apex Court in another case. So this is, I say, qualitative, not only quantitative, qualitative. Therefore, the role of the tribunals is most important. And another point I want to tell you, one matter was pending in Karnataka Appellate Tribunal for about 4 decades. 4 decades. That was the matter relating to the grant of land under Hyderabad Inam Abolition Act. See, it's so if the litigant is lucky, that matter comes before me. In the November 2011, what happened? The sitting was at Gulbarga. My friend Ruchik Judge member expressed that he is unable to go there. Then I said, I am ready to go. I went there. There are very few cases. It was the 1948 application filed by that poor litigant. Then I was shocked. What is this? You people say that there is a delay in courts. This tribunal is said to be very speedy way of justice. How it is? Then I heard that matter. What happened? There were 11 big bundles of the records. 11 big bundles of the records. Everybody is telling, no sir, this is heavy matter. No, I think that matter is not heavy. We have made it heavy by adding unnecessary files. I came back. I personally verified. Do you know, sir? The matter was 2 villages of Bidar district, Gullar Haveli and Aliabad. I remember those facts very clearly. One survey number which he has applied for was whether this belongs to Aliabad or Gullar Haveli. The proper person to speak about that is Deputy Director of Land Records. Deputy Director of Land Records has given clear-cut finding that this belongs to Gullar Haveli. There's nothing to do with the other village. Though merger has taken place, this has nothing to do with the applicant is entitled for this. But however, the revenue people were not ready to give it to him. When it went back to the Deputy Commissioner, he again dismissed it. Again it came to the Karnataka High Court, this MRAT, Karnataka High Court. Again it goes back. In this way, it has taken rounds from High Court, KAT to Bidar to KAT. Then ultimately, I have cull out everything, wrote a judgment, and said that the series of this litigation is like a TV serial. Episodes are dragged from one to another and made to languish in this. I wrote it and strictures passed and sent it to the concerned secretary. After 1.5 years, when I left the tribunal, the revenue representative told me that, sir, your order is complied. 50 years after the order is complied. This is the result of the tribunals. So tribunals are not just alternative, but the best alternative for the speedy justice to the people. And it's my opinion that the chairman and the registrars play an important role in effective administration of tribunal. Now I am told that the present chairman of the KAT and registrars are very much interested in enhancing the quality of this work. I wished I should have been here at this juncture. But anyhow, sir, see, this is not just but best alternative. And I had 2 interactive sessions with my staff there as to how administratively we can take the benefit of. Adjudication matter is done by the district judge and department members. But administrative matter, if the order doesn't reach the person, again there is a problem. I had 2 interactive sessions with them. So they are all cooperative, and more so the staff, if we train them, they will be of much assistance to us. Particularly in appellate tribunal, I have never faced any problem from the advocates here. They were ready to argue with the matters. The other one matter, it was relating to the service conditions of the Cooperative Milk Union, Kolar. See, in the last 6 months, I have posted to this cooperation bench. There, a matter which was languishing for 10 years. See, we see that when our DA is not given, we are much bothered. When our increment is not given, we are much bothered. Those people were struggling hard for 10 years to get the relief. When I was transferred to that bench, I took up that matter in 2012 when it was filed in 2002. And I decided the matter. Therefore, of course, the delay is because of other reasons, I know, but the justice was done. Last, giving one example, I conclude my speech. The problems, this tribunal has got an important role, as a fact-finding body. When I was sitting in the cooperative bench, I was shocked to see a judgment of the arbitrator. I don't call it a judgment. It is an order that man has written in such a fashion. The person who has come before me was left with no alternative except to hang himself. Do you know that what has happened? He has applied for the loan of 28 lakh rupees to the cooperative bank. There was a delay for purchasing the house. There was a delay in sanctioning the loan. What happened? That poor fellow, owner said, if you don't purchase it, I will sell it to others. So that poor fellow arranged the funds elsewhere, purchased the house. And this bank sanctioned the loan, and to whom it should be given? It should be given to the person who has applied for. No, they have given it to the person who has sold a house. This man has taken 28 lakh rupees from this poor man, and 28 lakh rupees from bank, 6 lakh rupees ran away. See, he says that you have sanctioned loan but not given to me. He went before the arbitrator. Arbitrator never applied his mind. No, it is sanctioned to you. But if mere sanction is one thing, giving it to the loan is another thing. He gave, you pay this 28 lakh rupees principal, 28 lakh rupees interest. 56 lakh rupees award passed him. I remember that it was 2012, March 22nd. March 28 is the day on which the auction of the house of that poor man at no fault of his was fixed. I heard that matter on 22nd, passed the order on 25th of March, and set aside the judgment with the strictures, saying that this is gross injustice done by the arbitrator. That auction was postponed, and later the department officers told me that we had taken action against that bank. Yes, that is why, sir, these are not just alternative, best alternative, and the best decision of the government, and they have taken much burden of the High Court. Therefore, in my opinion, this is the best alternative, not just alternative. I thank the administrator for giving me an opportunity to express myself about what I felt, and it may be of some help. Thank you.